Good afternoon, everyone, and welcome to today's SRC Lunchtime Chat, co-hosted with the Caribbean Policy Consortium. My name is Alicia Nichols, Junior Research Fellow at the SRC, which stands for the Srinath Ramphal Center for International Trade Law, Policy and Services here at the University of the West Indies in beautiful Barbados. On behalf of the SRC and our director, Dr. Gianni Fremi, we are honored to co-host this timely and critical discussion in partnership with the Caribbean Policy Consortium, CPC. Just a little bit about the SRC before we begin. The SRC stands as the Caribbean's premier trade policy research, training, and outreach institute. And for over 2 decades, we have been at the forefront of shaping the region's trade professionals through our Masters in International Trade Policy program. Beyond training, our mission is to serve as a thought leader and convene meaningful conversations. And today's discussion is exactly that. The global tax landscape is shifting rapidly, and the OECD's BEPS Pillar 2 framework presents profound implications for Caribbean economies, but also opportunities. And this session is an opportunity to dissect not just these developments, but engage in critical discourse and shape informed regional responses. I thank you for joining us. A very warm welcome to you and our esteemed panelists, and we look forward to a stimulating and thought-provoking discussion. With that, I will now hand over to our moderator this afternoon, Mr. Bruce Sagaris. Over
Uh,
to you, Bruce.
Good afternoon, and thank you very much, Alicia. And let me also congratulate the Ramphal Center for all the great work that they've done already. I also want to say something about the Caribbean Policy Consortium, which is one of the co-hosts. Founded in late 2020, the CPC is focused on Caribbean policy work, supported by a network of policy and academic institutions in the Caribbean and North America, such as the Ramphal Center, against the backdrop of focused approach on Caribbean policy interests. The CPC successfully forged strategic partnerships with the objective of widening the initiatives geared towards the Caribbean. Now, I am an attorney with the law firm of Berliner Corcoran and Rowe in Washington, D.C., and it especially is a pleasure for me to moderate this program, because when I was a kid, I was on the faculty of the University of the West Indies, where this is, which is the co-host. So let me first just give you a brief introduction of the panelists. We've got a great set of 3 panelists. First off will be Michael Durst, who is based in Washington, D.C. He's a longtime U.S. tax practitioner. He's an author on international taxation in developing countries. He's a former government official and a law professor, and he's now a researcher at the International Center for Tax and Development. In the government, he was the director of the IRS Advanced Pricing Agreement Program, and I've worked with him the last couple of years on programs on international tax in developing countries. Michael is going to talk about the Pillar 2 in developing countries. He will be followed by Lynette Eastman. Lynette is also a fellow at the Caribbean Policy Consortium, and she is the lead counsel in Eastman and Company, a law firm in Barbados. She was formerly the Minister of Commerce, Consumer Affairs, and Business Development, as well as Director of International Business for the government of Barbados, which is, one of the places where I encountered her. In her government role, she was also the lead negotiator for services for CARICOM, and she was the negotiator of double tax agreements and bilateral investment treaties for the Barbados government. And she was also the lead negotiator in the matter of the OECD initiative on harmful taxation, which is really what started this whole thing about BEPS and Pillar 2. Following Lynette will be Bevan Sinclair. Bevan is the Chief Technical Advisor to the Commissioner General and the head of the Dispute Resolution Division for the Tax Administration of Jamaica. Bevan also has represented Jamaica at the Inclusive Framework, and he also is on the team that negotiates international tax treaties for the Jamaican government. So before I turn the program over to the panelists, I will just give a brief overview of Pillar 2. And it's, I must say, a real challenge to give a brief overview because it is very complex. But the Pillar 2 model rules, which are also referred to as the Global Anti-Base Erosion or GLOBE rules, they were released on December 20, 2021. And they're part of the Pillar 2 solution to address the problems of the digitalization of the economy that was agreed to by 137 member jurisdictions of the OECD G20 Inclusive Framework on BEPS. And it was also, of course, endorsed by the G20 finance ministers and leaders in October of 2021. So what are they? The Pillar 2 model rules are designed to ensure that large multinational enterprises pay a minimum level of tax on the income arising in each jurisdiction where they operate. The rules run about 45 pages and another 15 pages of definitions. And I should add that since then, there have also been 7 different sets of administrative rules and explanations that are part of the package. So it's very dense in terms of all of the rules. So they are drafted as model rules that provide a template that jurisdictions are supposed to translate into domestic law to assist them in implementing Pillar 2 within an agreed time framework and in a coordinated manner. Taxpayers that either have no foreign presence or have less than 750 million euros in consolidated revenue are not within the scope. So again, this is only for multinational enterprises that have 750 million consolidated revenues. There are also excluded entities. So the Pillar 2 rules do not apply to government entities, international organizations, nonprofits, pension, investment, or real estate funds. And taxpayers that are in scope of the rules, they then calculate their effective tax rate for each jurisdiction where they operate, and then they pay a top-up tax for the difference between their effective tax rate per jurisdiction and the minimum 15% rate. Once the effective tax rate is calculated, the tax divided by the income and aggregated on a per jurisdiction basis, Chapter 5 of the model rules determines how much top-up tax is owed. So the rate is the difference between the 15% minimum rate and the effective tax rate. They often use the acronym ETR in the jurisdiction. So the top-up tax percentage is then applied to the globe income in the jurisdiction after deducting a substance-based income exclusion. And the substance-based income exclusion reduces the exposure to the minimum tax, and that's calculated as a percentage markup on tangible assets and payroll costs. And those rates go down over the 3 or 5 years that they are can be calculated. And then finally, if a jurisdiction has a domestic minimum tax that is consistent with Pillar 2 model rules, they're then called the qualified domestic minimum top-up tax, or QDMTT. Such domestic tax eliminates any top-up tax liability under the GLOBE rules when they're treated as a QDMTT safe harbor. So then there are some interlocking rules that I should mention. Because the way that the global minimum tax, or Pillar 2, operates is through these interlinked rules. So a liability to the top-up tax exists for a member of an in-scope multinational enterprise under 2 types of provisions. The primary rule is the income inclusion rule, and under the income exclusion rule, or IIR, the minimum tax is paid at the level of the parent entity in proportion to its ownership interests in those entities that now that have low taxed income. Generally, the IIR is applied at the top, at the level of the ultimate parent entity, and it works its way down the ownership chain. Rules are also provided to allow the IIR to be applied by a parent entity in which there's a significant minority interest. And that's to, of course, minimize the leakage of low taxed income. There is also something called UTPR, the undertaxed profits rule. That's a backstop. So to ensure that the minimum tax is paid where an entity with low taxed income is held through a chain of ownership that does not result in low taxed income being brought under the IIR. So the rule works by requiring an adjustment, such as a denial of deduction, that increases the tax at the level of the subsidiary. And the adjustment is an amount sufficient to result in the group entities paying their share of top-up tax remaining after the IIR. And the share of the top-up tax is calculated based on a formula in proportion to the relative shares of assets and employees. This helps to ensure that the rule is administrable, but it also attaches the adjustment to entities that are most likely to have the capacity to pay the required amount of top-up tax. And as we'll discuss, the UTPR has been quite controversial because a number of experts have said that it may violate Article 5 permanent establishment of income tax treaties. There's also one other interlocking rule, which is called the subject to tax rule. So that was agreed by a consensus basis of the members of the inclusive framework, who also adopted an elective multilateral convention to facilitate the implementation of Pillar 2. It's called the multilateral convention has the acronym MLI, and the subject to tax rule has the acronym STTR. So the way that works is it ensures that a minimum level of taxation on relevant cross-border payments, and it's designed to prevent circumstances where income is either taxed at very low rates or not taxed at all due to differences in the tax regimes between countries. So what happens is members of the inclusive framework that apply nominal corporate income tax rates below 9% to income covered by the STTR have committed to incorporate the STTR into the income tax treaties with members of the inclusive framework that are developing countries when they are requested to do so. So the STTR allows jurisdictions, the developing countries, to tax back where defined categories of income are subject to nominal rates that are below the 9%. And domestic taxing rights over that income have been ceded under a treaty. So the STTR then is part of the package of rules, and it complements these other rules. And there are more than 70 developing country members of the inclusive framework that are eligible to request inclusion of the STTR. And by the way, according to a legislative tracker issued by Pricewaterhouse, there are 55 countries that have QMDTT that will have it by 2026. And there are 32 countries that will have a UTPR by 2026. In fact, Japan just recently has started their parliamentary process for a UTPR. So once the three panelists have spoken in the discussion period, we'll have a lot to talk about, including the UN Framework Convention on International Tax Cooperation, as well as recent initiatives by the Trump administration. But let me stop here and let me turn the panel over to Michael Durst. Michael?
Thank you, Bruce. That's wonderful. You've done a wonderful job summarizing what is, as you pointed out, a very complicated new tax regime. What I'd like to do is focus on the basics of that regime, and I'll give a little example and try to show how the developing countries really need to be reacting in one way or another to the Pillar Two enactment. Right now, really, quite promptly. Let's say that a French parent company in the hotel industry, a company that a group that has revenues of more than 750 million euros, so it's in scope of Pillar Two, establishes a subsidiary, say, in your country, in the Caribbean. Under Pillar Two, if the subsidiary in your country is paying an effective rate of under 15%, the first rule is that the parent company in France can apply a top-up tax to the group. Now, remember, this is not a great thing from the standpoint of the country that's hosting the subsidiary, because the subsidiary ends up paying a tax at 15%, which eliminates any of the effect of any incentives that you that you were offering the company. But the tax that is imposed to make up for the incentive is collected not by your country, but by the parent country. Now, when that rule was first revealed in the OECD negotiations, developing countries were quite upset about it, because if there was going to be a top-up tax, they wanted to receive the revenue, not the country that's close to the common parent. In my example, France. So the opportunity for countries to adopt QDMTT, qualified domestic minimum top-up taxes, was added to the Pillar Two rules, and basically a country that hosts subsidiaries of in-scope multinational groups, so that host in-scope subsidiaries, really needs to enact QDMTT or some similar arrangement in order to so that your country collects the top-up tax rather than the country that is the resident country of the parent company. There are numerous and there are various variations on the QDMT, and actually, it's possible to enact a QDM simply rather than enacting a QDMTT, you can simply change your regular corporate income tax rule to eliminate incentives. So that might be very difficult to do. So I think that every country that is host to subsidiaries that are in scope, subsidiaries that are members of groups with more than 750 billion euro revenue, are seriously considering adopting QDMTTs. And to the extent that a country, one of your country, has not yet addressed this issue, I think it's really necessary that you do so. Now, the way to determine, you should survey your taxpayers to your tax system to determine whether you do have some subsidiaries that are subject to the Pillar 2 rules. So you would first try to identify any subsidiaries, and a great many countries in the Caribbean will have such subsidiaries. In for example, the tourism business, global hotel chains, for example, would be a prime candidate for this situation. You want to see what the effective tax rates are of the subsidiaries in your country, and there's a little bit of a tweak here. Under the Pillar 2 rules, the effective tax rate is determined not under your regular tax rules, but really under the effective tax rate is computed with respect to book income, financial statement income. So in order to do the survey, you need to be familiar with the book accounting rules. And the OECD in its guidance has numerous suggestions as to how to apply the generally accepted accounting rules or equivalent to figuring out what the ETR is of your subsidiaries. And if it turns out that you have significant representation of such subsidiaries, in-scope subsidiaries that are paying tax at an effective rate of less than 15%, it's really necessary for you to figure out how to address that, probably through the implementation of a QDMTT or other ways, so that basically the parent, the host, the residence country of the parent company doesn't end up eating your lunch. I presented this in a relatively simplified manner. There are numerous complications to the survey that you'll necessarily that you need to do. A major implication is that the United States has decided that it will not participate in the Pillar 2 framework, so that U.S. parent companies will not be subject to the income inclusion rule. The U.S. won't collect the top-up tax. It's possible that within that another company, another subsidiary, an intermediate parent company within the U.S. controlled group will in its country will apply the IIR. So you really need to look closely at the composition of the group. And it's also possible that even for a U.S.-owned group, another country will impose tax under the UTPR. But the United States has indicated that it will retaliate against countries that try to apply the UTPR with respect to American-owned groups. And so we really don't know what the ultimate effect is of the U.S. decision to participate in Pillar 2. So the bottom line is that you need to look at the companies in your jurisdiction, figure out which ones are members of in-scope groups, which ones are in-scope subsidiaries. You need to determine the effective rate, and then you need, if it turns out that there's significant top-up tax liability on the table, you need to take measures to ensure that top-up tax is collected by your country, not by the country of a parent member of the group. With that, I think I'll hold off until I'll wait for questions, which I'm sure will be forthcoming, and we can talk some more about this.
Okay, thank you very much, Michael. Yeah, we already have a question about the impact of the US's proposal to withdraw, but I think let's hold that for the discussion period right now, and let's hear from Lynette.
Okay, thank you, Bruce. I want to do a slide presentation, so I'm going to share now.
Okay, we can see that fine, Lynette.
Okay. Okay, right, okay. So, in terms of looking at BEPS from a CARICOM perspective, there's some issues that I would like to address very quickly, and then if we want to, we could look at them further. The first thing is looking at the politics of the whole base erosion and profit shifting initiative, the regulation of economic activity, looking at the tax rates, tax incentives and subsidies, because that's very important for the region, residence and substance versus substance taxation, and generally looking at CARICOM activity where this particular initiative is concerned and international tax initiatives generally. So here I just want to point out, because sometimes we can get lost in the technicalities of these tax issues and not quite recognize that the initiatives are driven by international politics more so than anything else. And everybody knows that when it comes to taxation, it's not like thou shalt not steal, and therefore you implement rules, regulations, or laws against stealing. This is really a statute-based area that really countries decide what is in their best interests and put legislation or laws or treaties in place to suit themselves. So we can see that this whole initiative started from, at least CARICOM was fully aware of it from 1998. And CARICOM responded very well. CARICOM set up an organization, the International Tax and Investment Organization. It responded to the OECD harmful tax competition by putting out a publication which was commissioned by CARICOM and other small states, countries like that you might not think of, like Malaysia, the Cook Islands, Vanuatu. All of those countries participated in actually responding in writing to the OECD. And after all of this, the US withdrew its support in 2001 when the George Bush administration came in. And a global forum was set up, which the targeted countries were invited to participate in, and they did so. I think it is unfortunate that the International Tax and Investment Organization or something similar did not continue to exist in order to prepare CARICOM countries and other small states for dealing to deal with these OECD initiatives. So you would see that this started since 2012, but it was languishing until Joe Biden was elected. And then it got some more impetus. And the Biden administration said that it supported the 15 action items because remember, Pillar 1 and Pillar 2 are part of a whole set of initiatives meant to deal with the race to the bottom or erosion of the tax base of countries, etc. So now we have in 2025, the US withdraws its support. Now, while the US withdrew its support in 2001, the OECD had not really got that far. The withdrawal of the US in 2025, it might be a different story because many countries, as our two last speakers said, have already gone ahead and they've implemented legislation. So the next I want to look at is international law and the regulation of economic activity. So all CARICOM countries are members of the World Trade Organization and the United Nations. The OECD has done a lot to massage its image coming out of the harmful tax competition. These pillar 1 and pillar 2 are called the G20 OECD BEPS. That's deliberate. That's so that it is not just the OECD. It's now a wider grouping of the G20. They've created an inclusive framework, which they say that you're a member of, but I do not think that you can have an equal footing at a table where an equal seat where the inclusive framework belongs to the OECD. They can decide to do away with it tomorrow. So I don't think that that is a level playing field at all. And I think CARICOM must always be cognizant of the fact that they're not members of the OECD. They're not members. There have been recent developments at the United Nations in terms of, and the General Assembly last year approved the framework for international tax cooperation. Some would argue that the large OECD states who are at the forefront of the taxation issues, that they're also members of the UN, so that they will be very powerful in terms of determining what comes out of the UN initiative. Tax rates. Now, in the 1998 OECD report on harmful tax competition, the countries which were in scope for blacklisting were those which had low or nominal tax rates. This was the premise on which countries were going to have their economic activities undermined because of low tax rates. So it turns out that the OECD did a study in 2024, and it shows that 53% of low tax profits are found in high tax jurisdictions. So this is what Bruce and Michael were talking about before, the effective tax rate. The issue is really, what is the effective tax rate, not what the statutory or nominal tax rate is. And basically, back in the day, in 1998, this is what the OECD was looking at. So Barbados had recognized for a long time, and this is why Barbados could move to reduce its tax rate, because of the number of incentives that we have. There were many companies who were paying tax at a lower effective tax rate than the nominal tax rate of 40% or 30%. So under Pillar 2, Barbados has put a 9% rate across the board. Bahamas is at 15%. And the issue of tax rates will continue to be an issue. Tax incentives and subsidies. So this is going to then be linked to tax rates. When you utilize subsidies, your effective tax rate is reduced. What is interesting is if you look at the literature, you would see that the World Trade Organization, not the World Trade Organization, yes, but entities like the World Bank and the International Monetary Fund have been arguing for years that developing countries should not use subsidies, that it is not in their interest. And what came out of the WTO is that there was an agreement on subsidies and countervailing measures, which CARICOM countries signed on to, and had a period of time within which they would remove their subsidies. Some of you may remember that many countries had a foreign sales corporation regime, which came to an end. And that was because of the use of this agreement on subsidies and countervailing measures. The EU took the US to court basically on that. But it, however, seems as though maybe it is to get developing countries on site, the OECD is not as strident on incentives. So they have this substance-based income inclusion rule, which Bruce spoke about. And they have also allowed Barbados not only introduce the 15%, but also introduce a jobs credit and a research and development credit. So I thought that was very interesting that the days of subsidies don't seem to have come to an end. In terms of that OECD report, they're now categorizing countries as high income, upper middle income, lower middle income, low income, and investment hubs. So within CARICOM, Barbados and Bahamas have been declared to be investment hubs. I am always very wary of being singled out and named by any entity. So we'll have to see where that goes. Now, in terms of residence and source taxation, this has, traditionally been one of the issues that you would see coming up in international tax. So we have an OECD model convention, which generally speaking, gives the country of residence the primary right to tax. You have a UN model, which was drafted primarily for developing countries, which seeks to favor source taxation. And you see that through the PE article and their withholding tax articles on dividends, etc. Our CARICOM treaty is based on the Andean model, which is a source-based model. And so essentially, you see the OECD at this point giving some more credit to source-based taxation by using the qualified domestic minimum top-up tax, giving the country of source the first right to tax. And also, I would bring into that framework the subject to tax rule, which through double taxation agreements, it actually gives the source country another opportunity to levy a higher level of taxes on income that is generated from the jurisdiction. Now, CARICOM has been discussing these issues at the CARICOM level, and CARICOM has also had interaction with the OECD, particularly coming out of the discussions with the OECD. The CARICOM made a commitment to do a study on the impact of Pillar 2 on CARICOM countries. So I'm not sure where that is. Bevan might be able to help us with that. So Bahamas and Barbados have definitely implemented the aspects of Pillar 2, which they believe to be beneficial to them. And I understand that Jamaica is about to implement that very soon. In terms of CARICOM future responses, I think it is important for CARICOM to develop its own international tax policy outside of organizations like the OECD, because our international tax policy must suit us. The OECD is carving a tax policy that suits them, no matter what the window dressing might be. We have to determine how important these tax developments are to CARICOM economies, and I think we need to prioritize initiatives that are important to us. So for example, next in line for the OECD is transfer pricing, but like, is that a priority for all of our countries? It might be for Trinidad, might be for Jamaica, but is it for Barbados? And finally, I would say that there must be a cross-cutting development of policy within the region, between trade, finance, and foreign affairs, because they're all linked. And these initiatives are not only being developed in tax fora, they are developed in other fora as well. And I think the region needs to be conscious of that. So I'll stop there. Thank you.
Well, thank you very much, Lynette. You've left a lot for discussion, all kinds of things. But before we get to the discussion, I want to turn it over to Bevan and hear about Jamaica's implementation of Pillar 2. Bevan?
Yes, good afternoon. Thank you very much, Bruce. Good afternoon to the other panelists and to the audience. My focus today is to look at the state of play in Jamaica in terms of where we are in relation to the GLOBE rules. I'll start by giving just an overview of Jamaica's economic and tax regime and look at some of the incentive regimes that we have, the risks associated with them, and also look at our policy options that we have adopted for the implementation of the GLOBE rules. So Jamaica has been a member of the inclusive framework since 2016, which would have been the inception for most developing countries. For the purpose of GLOBE rules, we are a developing country. We have our GNI per capita of just US $6,200, which is way below the benchmark established by the OECD in 2019 of $12,000 that would determine your categorization. Jamaica is service-based economy, mainly tourism and business process outsourcing are the main drivers of growth and foreign exchange earnings. We have headline rates of 12.5% for our special economic zone, and we have 25% for our unregulated companies and 33.33% for regulated companies. Jamaica did a major reform of our income tax incentives in 2014. And during that period, we moved away from sector-based incentives where we had tax exemptions and tax holidays. So currently what we have in place are broad-based employment tax credit. And this is basically a function of payroll-related taxes that are paid on time. Also in the special economic zone, we have what is called the promotional tax credit, which covers R&D and training-related expenditures. In relation to the implementation of the GLOBE rules, Jamaica is at a preliminary stage of our legislative process, where submission has been made to Cabinet to approve the implementation of the GLOBE rules. Specifically, we are asking Cabinet to approve the promulgation of tax legislation to give effect to the GMT, including the income inclusion rule, and also the qualified domestic minimum top-up tax. Those we consider, based on our assessment, as the priority areas that we would want to provide and give some attention to. The QDMTT, we think there is some upside there for us in relation to entities of foreign headquarters companies that are in scope within Jamaica. We have been working with the OECD and the World Bank in designing and implementation of the rules. And based on preliminary projection, we think the rules will be effective in 2026. we have been looking at our data in relation to M&Es, and as of 2023, we had approximately 80 M&Es that are within scope, and that is M&Es with group turnover in excess of 750 million euros. I must say that majority of these entities are US subsidiaries, and so we're assessing the impact of the recent pronouncements by the Trump administration. In terms of our risk analysis and the impact of the minimum tax of 15%, we believe the special economic zone entities that are within scope will be negatively impacted if Jamaica does not adopt the QDMTT. As I've indicated before, the headline rate for these entities is currently 12.5%. And with the incentives, the employment tax credit incentive and the promotional tax credit incentive, that rate can go as low as 7.5%. And so, we are analyzing those entities to assess the impact. We also have within the special economic zone developers whose rental income would also be exempt. So those entities, to the extent that they are within scope, will be at risk. In terms of the substance-based carve-out, we think, given the fact that these entities have high levels of employment and tangible assets, that there may be some ameliorating factors there as far as it relates to the substance-based carve-out. But we are still doing the analysis in relation to that. The other incentive regime that we have is the Large Scale and Pioneer Industries Act, which provides for a tax credit that can result in effective tax rate of 0% or therearound. And so entities that, and this relates to entities with approximately $1 billion worth of expenditure. So more or less these entities will come within the scope of the GLOBE rules. And so we are assessing the impact on that industry sector as well. In terms of the implementation of the qualified domestic minimum tax, we based on our assessment, we think it is best that Jamaica, rather than ceding our taxing rights to other jurisdictions, that we capture the tax in relation to those entities that are in scope and are below the effective tax rate. And, we see significant upside in relation to income potential from those. We have also had representation from MNEs that are headquartered in Jamaica, that they believe that Jamaica should also adopt the IR rule, which is a part of our legislative, proposed legislative framework now. And the reason for that is because they are of the view, the entities, the MNEs headquartered here, are of the view that there is significant potential tax that will be gained in relation to those specific MNEs, and they would want that income to be accrued in Jamaica. So it is on the basis of that we are going ahead with the QDMTT and the IRR. And we know the caveat in relation to the IRR is provided that the other jurisdictions have not adopted the QDMTT. We are not considering the subject to afford and China, however, expressed an interest in an MLI for Jamaica to include this as a part of the double taxation treaty agreement. We will certainly comply with that. As far as it relates to the undertax payment rules, currently that is not being considered at this time. And, you know, we are looking at the implementation using the reference model with the assistance of the World Bank and OECD. My last comment is, you know, to other jurisdictions who are contemplating whether or not they should adopt the globe rules, that, you know, you must make a detailed assessment of the possible impact, whether or not you are going to implement, because to the extent that you have MNEs within your jurisdictions whose the other entities, the headquartered entities, the countries for those headquartered entities have implemented, then you may be negatively impacted by those rules. And so, you know, you must assess what the rules, how the rules may impact your jurisdiction. So that's all I have to say for now, Bruce. Thank you.
Okay, thank you very much, Bevan. So we've got a few comments and questions already. So one of the questions is, what is the impact of the US proposal to withdraw from the Globe framework? And maybe I should just set the stage a little bit by highlighting what the US has done. So on the day he was inaugurated, President Trump announced his America First trade policy in an executive order. He directed the Secretary of the Treasury, in consultation with the Commerce Department and the US Trade Representative, to investigate whether any foreign country subjected US citizens or foreign corporations to discriminatory or extraterritorial taxes pursuant to Section 891 of the Code. And he announced that the OECD, what he called the global tax deal, which I think refers to both Pillar 1 and Pillar 2, we're only talking about Pillar 2 here, has no force or effect in the US. And he directed the Secretary of the Treasury and the permanent representative of the US to the OECD to notify the OECD that any commitments made by the prior administration on behalf of the US with respect to the global tax deal have no force or effect within the US, absent an act by the Congress adopting the relevant provisions of the global tax deal. And he also directed the Treasury Secretary, in consultation with the US Trade Representative, to investigate, quote, whether any foreign countries are not in compliance with any tax treaty with the US, or have any tax rules in place, or are likely to put tax rules in place that are extraterritorial or disproportionately affect American companies, and to develop and present a list of options to the president through the Assistant to the President for Economic Policy for protective measures or other actions that the US should adopt within 60 days. And then, you know, also the chairman of the House Ways and Means Committee has reintroduced a bill called Defending American Jobs and Investment Act, which would retaliate against those jurisdictions which supposedly have extraterritorial or discriminatory taxes. So let me turn to the panelists and ask them what impact they think the proposals of the US are going to have on Pillar 2, especially on the other countries and especially with respect to the Caribbean? Who wants to take a crack at that?
Let me take a crack at it, but I'm afraid not give a very definitive answer. I think it's much too early to tell what the effect of the U.S. withdrawal from Pillar 2 is. I think that one now a lot depends on what the composition, on the composition of your own foreign inbound investment is. If your subsidiaries are predominantly or exclusively subsidiaries of American groups, then you may not want to enact a QDMTT or otherwise increase your domestic tax rules. But before doing that, you have to make sure, you have to consider whether countries other than the United States, which will have opted out of Pillar 2, will impose IIRs or QDMTs further down the chain from the ultimate U.S. parent. So it's a very complicated calculus that you really need to get involved in. And I think that the most important lesson or idea suggestion you can take from this panel discussion is that these questions need to be considered quantitatively, carefully, along the lines of what Bevan described for Jamaica. That CARICOM probably wants to get involved in assisting member countries to do these kinds of evaluations. And maybe, Bevan, you could speak a little bit more about the collaboration you've had with IMF and the World Bank in doing the evaluation on behalf of Jamaica.
If I may, I think that Jamaica might have started to have some thoughts after the announcement was made by President Trump. And yeah, so I think since Bevan right now is in the middle of considering this implementation, he might wish to share some of those thoughts with us.
Yeah, absolutely.
If you
Bevan,
can.
Yes, so from our perspective, it is still preliminary in terms of where we are at in terms of our consultation. We haven't engaged our international tax advisors, being the World Bank and OECD, in respect of the analysis. They would have helped us in terms of the analysis of the data and also the economic impact. Now, we'll have to take it a step further, given the fact that a lot of these MNEs have presence, whether USA is their headquarters or they have other entities within the USA. And we see that as significantly impacting all the analysis that we would have done in trying to determine, for example, the economic impact of implementing these rules, to the extent that it might stymie, for example, the implementation of our QDMTT, then we'll have to reassess to see whether or not, based on the cost benefit analysis, whether or not it is still a go. I would want to also see how the inclusive framework will approach this withdrawal by the USA to see whether or not there will be any engagement in relation to that, to see how that can be qualified, or whether or not there will be any changes from that perspective. We know some of these things are highly political, and so we will have to await the deliberations at that level before we proceed further in terms of making definitive policy decisions.
It would seem to me that historically the US withdrawal from any of these stocks have caused them to lose momentum. However, as we saw with the OECD initiative, it lost momentum, but the OECD did not stop working. It continued to work, and then a political opportunity arose where then it was able to implement its work. So I assume, I don't know, does President Trump get to run again? There was a break, right? So he,
No,
He's not,
absolutely not.
sorry?
he's not supposed to, but recently he's said that he's considering. He's
Well,
not,
he,
Okay,
yeah,
so,
He's
I
not-
think
it
he,
isn't
he,
two consecutive terms, it's,
no,
He's-
it's
I forget if there's a break, you
total.
can run twice.
Yes, that's what the Constitution says. Uh, some people, I think and hope, jokingly suggest that, well, maybe President Trump he'll try to get a constitutional amendment passed, which is a very difficult thing to do, allowing
Okay.
him to run again. But I think the likelihood of that is very low. But remember, President Trump is just beginning his 4-year term. So if he's really not subject to any kind of political pressure. Now, let me try to put this whole U.S. withdrawal into political context. Pillar two, the consensus that was built around it until the U.S. pulled out, reflects a judgment, really a consensus around the world that tax competition needed to be curtailed, at least to some extent. And so the regime was put in place, which tries to ensure that every company doing business anywhere in the world will be subject to at least a 15% tax rate. And that was based on a consensus that tax competition was driving rates globally below a socially optimal level, below where they should have been. So that tax competition was perceived as something undesirable. The Republican Party in the United States, at least the Trump wing of the Republican Party, has a very different view of tax competition. They believe that corporate income taxation is undesirable at any rate, and so they have no interest in a regime of curtailing tax competition. They think tax competition is desirable, and that's what's going on here. And it's a very dramatic change from the U.S.'s position, which was probably more independent and standoffish about international cooperation, tax cooperation than some other countries, but still the U.S. participated. Now the U.S. has taken a very definitive move away from international tax cooperation. Not only has the U.S. pulled out of Pillar 2 and Pillar 1, which is not likely to be enacted anywhere anyway, but also the U.S. has pulled out of the UN framework law. And so we have to get used to this political reality, which many people, and I'll be frank, I included, uh, regret. But it's a very powerful change in the global environment.
So let me just say a couple of things here. So Lynette mentioned that in 2001, the U.S. withdrew from the harmful tax competition. Well, what the U.S. did there was they only withdrew from part of it. And they said, as long as there was no more secrecy, and as long as there was exchange of information, that was okay, that part of it. But the Paul O'Neill, the Secretary of the Treasury at the time, said the OECD should not have a right to say anything about tax rates. But, now we're talking about tax rates. So that shows, as Lynette said, how the initiative has continued. In fact, when it first was started, the Pillar 2, it resulted from the Trump administration's Tax Cuts and Jobs Act, the fact that there was a GILTI, and the U.S. was very much a robust participant in the initiation of Pillar Two, even though now they're saying they want no part of it. So, how we end up is going to depend a lot on, different political dynamics, including the tariff or the trade wars that are just starting, among the different parties of the world. Because I think, all of this is going to be somewhat intertwined, and it's hard to predict.
In terms of the Pillar One and Pillar Two solution, I think that if you examine all of the various pieces of legislation that seek to deal with companies being established, subsidiaries being established in low tax jurisdictions. You have the CFC rules, you got your transfer pricing rules, you have anti-avoidance rules, you got case law, you got all that stuff. And Pillar One and Pillar Two is trying to resolve some of those issues so that you don't have a multiplicity of pieces of legislation, some in treaties, all kinds of things, trying to deal with one issue. And I think most people who look at that, because that's what mainly international tax is about. It is about trying to avoid this double taxation, but also double non-taxation. And a lot of time is spent on these CFC rules, transfer pricing rules, anti-avoidance rules. And I think most people, even if they don't like aspects of the OECD approach, they recognize that all of that is a bit futile. It takes up too much time. It makes tax administration more complex, you use more resources, all that kind of stuff. It's better to have a more simple approach. And Pillar One and Pillar Two is a simpler approach, So I think that even though the US has withdrawn, because what I was going to say is that even when the US withdrew, and Bruce, I never saw the tax competition and the secrecy as being part of the same dynamic. If you read the OECD report on harmful tax competition, they always said that their issue was with geographically mobile services, which is the same digitalization of the economy. They had that problem from back then. The secrecy, that was to sweeten the pot for those who don't like secrecy. So the whole idea was that all of these countries down here are involved in bank secrecy. People put their money down here and you can't tax it. I think that that was what that was about. But I really think, because remember at this time, we were also doing trade negotiations at the WTO, and services became a big thing, the same digitalization of the economy. And how do you tax these entities that are involved in the digital economy, services, etc.? So my view would be that, I mean, obviously I don't know, but I think the work, you see the thing about the OECD, they have a number of technocrats that every day they go to work to work on this stuff. And they will continue to do so, they're not going to be fired. So all of this will continue. The OECD the US might have pulled back, but I think the work will continue. There's so many countries which have implemented legislation. I think you will just find a way to work around whatever the US position is.
I hope you're right. Let me though suggest and insert a note of caution here. The basic structure of Pillar Two, which I agree was very well conceived, that is very well conceived, is that the countries of the world band together to agree that their multinationals, that in order to permit countries around the world to raise revenues and to avoid tax competition, the countries of the world agreed in Pillar Two that their multinationals all would agree to be taxed at least a 15% effective rate wherever they did business in the world. Now that one major country has essentially broken the agreement, broken the cartel, in a sense, to use the word, are other countries going to be content to watch the U.S.-based multinationals being taxed at rates much lower than 15%, while still compelling their own multinationals to be taxed at the 15, requiring their multinationals to be taxed at the 15% rate? I'm just wondering whether the agreement that made Pillar 2 possible might be vulnerable to the desire of countries other than the U.S. to compete with the U.S.-based multinationals. I don't know. I mean, others might have some prediction, but I think the story is just beginning, and I think that it's very, very important. As Bevan described, Jamaica is doing. They're very close to the discussion and to consult with international bodies at the regional and global level to make sure that we're staying up to date on how to respond to these very important recent developments.
Yeah, and the disputes also raise questions of non-discrimination provisions in double tax treaties. Also, the importance of non-discrimination or national treatment, non-discrimination and most favored nation provisions in bilateral investment treaties, as well as the many obligations that countries have in free trade agreements, not to mention the General Agreement on Trade and Services. So all of these different treaties are implicated when countries treat investors, differently. And so, I mean, it raises all kinds of, different difficult issues. But I see there's one question.
Just before you go, Bruce, I just want to raise an additional point. It will be interesting to see how the Belgian Constitutional Court rules on the current honor tax payment rule case that is before them, that the US has filed, made a submission in respect of. And because this case was filed in 2024, the recent developments no doubt will influence how the Constitutional Court rules, because as you mentioned, the whole issue of non-discrimination is a part and parcel of this case. So it's going to be a very interesting time in relation to how this case will unfold.
Yep. I mean, I think there's also going to be a rise of alternative dispute fora for tax, just for tax disputes, because right now there's no, efficient fora. I mean, there's the mutual, there's the competent authority provisions, but the inclusive framework has, alerted the international community to the fact that there needs to be more done in terms of providing for alternative dispute fora. Because, I mean, there's also arbitration provisions in double tax treaties, but, I think you're going to see more alternative dispute fora for international tax. I see there is a question that says, I think I heard Lynette say something to the effect that CARICOM should negotiate tax agreements. Does this mean that there should be one effective tax rate for all CARICOM member countries? Do Lynette or Bevan have any, or even Michael have any thought on that?
in my time, I know that CARICOM tax administrators have met to discuss one tax rate or one or a fixed set of incentives for all jurisdictions. But I know that there has never been, well, Bevan could say because I haven't been involved in it recently, but there was never any consensus really. And the question would be, is it necessary for each country to have exactly the same tax rate? My point really had to do with having a policy as to exactly what your policy is. And your policy could be that countries are free to set their tax rate. Now, I know that CARICOM countries, I think coming out of that meeting in Jamaica, agreed to the implementation of Pillar 2. But as you can see, countries are implementing it in different ways. So Jamaica, because of its tax base, has a different approach, say from Barbados or the Bahamas. And within CARICOM, I think it's going to be very, ministers of finance like to have as much autonomy over setting rates and providing incentives as possible. I think it's very difficult to get away from that. But I think when it comes to our interaction, CARICOM interaction with other countries, I think that we should have a strong policy on that. So say, for example, CARICOM had a policy of negotiating double taxation agreements. Well, then CARICOM should go about doing it. So if we're going to negotiate with Botswana, you know, all countries, all CARICOM countries, if they agree at finance ministers meeting, could all negotiate with Botswana. In terms of interfacing with the OECD or the UN, we should do studies because Bevan said he was involved since 2016. So that's a while ago. So at the outset, we should have done the studies that we needed to do. If we come together as a group, we could have shared the resources and be able to come up with a policy. I think Barbados and the OECS are probably largely the same, very similar. And then you have Jamaica and Trinidad and Guyana. And maybe you have Trinidad, Jamaica, Guyana, Belize, and Suriname. So, you know, it's possible. I don't think we're that different. I mean, the EU does it. So it's just that you would need the resources to do it. And because to me, if you have a single market and you believe in your CSME, you should have a single tax policy, especially as it relates to the outside world.
So Bevan?
Yes, just to add to that, Lynette, the whole question of tax harmonization was an initiative that started sometime in 2009. There were significant talks about harmonizing rates, capital allowance regimes, all of that. However, it never got off the ground and it was abandoned. So I don't think there's any desire in 2025 to revisit that. And so the type of cooperation and the collaboration that we would have would be on the lines that you spoke about, where CARICOM can speak as a single voice in the international forum in order to protect the common interests of CARICOM.
Michael?
The intent, of course, of Pillar 2 has been to protect countries, all countries, against the pressures of tax competition, so that in effect, and under Pillar 2, at least with respect to large companies, Pillar 2 basically establishes a uniform 15% rate for all countries in all regions. Whether that is going to succeed in light of the U.S. withdrawal remains to be seen. But to the extent that it succeeds even partially, now countries do have the kind of protection against competition, which made, and it's really tax competition that's made it impossible historically to harmonize tax rates across regions or globally. So, I mean, the whole thrust of Pillar 2 is to enable and even create a certain kind of tax harmonization and of course, the dampening of tax competition. The again, the success of that attempt in light of recent developments remains to be seen. But certainly, developing countries need to pool their analytical resources regionally, I think. And it's a very complicated environment. And I think, it's important right now for countries in the Caribbean and elsewhere to ideally through some kind of pooled analytical resources to figure out exactly what's going on in this very complicated environment and what the options are.
So in that regard, in CARICOM, there is something called COFAP, the Committee of Finance and Planning. And what has COFAP done so far with respect to Pillar 2 or related matters? Does anybody want to comment on that?
Well, certainly what I understand is that COFAP would have voted to adopt the Pillar 2 rules. And they have also been looking at the CARICOM Convention with a view to modernize. So, however, as Lynette would say, each individual jurisdiction would have their own nuances in terms of how they implement those rules.
So I see there's a question about, will the incentives granted to encourage new trade linkages with Africa be impacted by the global rules? That's referring to, of course, the initiative that CARICOM took, especially led by PM Motley, to develop better trade linkages with Africa, and that's also even resulted in some recent double tax treaties, at least between Barbados and other countries.
I mean, I think we have to bear in mind that there are certain thresholds that have to be met. When you go back to the 750 million euros for companies to be in scope, the tax rules that apply will still apply to those companies that are not in scope. So if you have a situation with a company, an African company, the rules will apply based on the legislation that has been implemented once the multinational enterprise is in scope.
But
I don't think it will necessarily have an impact to prevent trade. Well, Michael, you go.
No, I was just going to say that you make a very important point. 750 million euros is a lot of money. And there are many of your taxpayers, perhaps most, maybe even all of your significant inbound investors are going to be non-in-scope entities. And then you have a lot more flexibility as to how to treat them. So, I mean, clearly, as we mentioned earlier, one of the first step in analyzing your country's position is to determine the number, if any, of in-scope companies and determine what effective tax rates they pay.
Sorry, there's a question here that I think was one of the first questions about the current tax framework in Barbados and the Eastern Caribbean relative to, I guess, the offshore financial centers and what the impact would be on those. It's okay. So one of the first things I would say is that what are called offshore financial centers, which I deliberately never use because we're offshore of what? I mean, we're not offshore anywhere. So I usually say financial centers if people want to call them that. But what happens in terms of the establishment of financial centers, a lot of it is driven by tax planning. And I think people will continue to engage in tax planning. It may look different. Now, say for example, with Barbados, Barbados did very well out of a relationship with Canada, but basically it was based on having a treaty with Canada and Canada having in its rules a provision about exempt surplus. That if you had a double taxation agreement with the US, with Canada, the surplus of the company resident in Barbados would be exempt surplus. The profits would be exempt surplus when repatriated to Canada. And Barbados benefited from that. But then Canada changed that rule. Canada said that you didn't have to have a double taxation agreement. And therefore, countries like Bermuda, Bahamas, whatever else who didn't have a double taxation agreement, they then started to benefit from the exempt surplus rules. So having a competitive advantage changed. So over time, the traditional international business sector has changed significantly. But it still seems to me that tax planners still need to make money, lawyers and accountants. So they will take these rules and they will see how they can benefit multinational enterprises or enterprises or there are all kinds of issues. Can I keep my multinational enterprise under the 750 million euros level so that they're never in scope?
So another issue on this is that the inclusive framework is doing work now on related benefits because they have realized that a number of countries that have enacted new rules to comply with Pillar 2, they're also giving things like tax credits, government grants, and other benefits. And so now the inclusive framework is examining, whether those related benefits, how they should be treated under the Pillar 2. And so it's like you say, countries will continue to give different incentives, whether they're tax or non-tax. Multinationals, even a 2 or 3% difference in rates could be important. And also when it comes to individual planning, a lot of individual planning has to do not only with tax rates, but also with economic residence. It also concerns, all kinds of non-tax issues, such as, Canadians have often moved to Barbados, when they've been, 40 or 50 years old, partly because they just like Barbados as a country. They like the climate. They like all the outdoor activities that they can't do in
The beach
Canada.
is 5 minutes away.
Yeah, and so, you know, all of these factors are going to continue to play. I mean, for instance, the ability to have, you know, small ship or you know, yacht registries. You know, those will come into play in combination with incentives to attract people to live in different places. So, you know, I think, you know, all of these issues are not going to go away. They're just going to be dealt with in new frameworks. You know, some of it's going to be legal, some of it's going to be political. And, you know, I think we're going to still be wrestling with a lot of these issues. So I think we're at time now, but unless any of you have any last minute thoughts that you want to leave with the audience, Michael?
No, simply my suggestion is that countries in the region do pool their analytical resources. It's a very complicated, challenging environment, and hopes that people will work together on that.
Bevan?
Yes, I think, as Michael said, we have to continue the collaboration within the CARICOM Secretariat in order to find meaningful solutions to the challenges that we have.
Okay, thank you very much. And I want to thank again the Ramphal Center at UWI and the Caribbean Policy Consortium for organizing this discussion. And, you know, I think it's been very interesting and cutting edge. And I think we're going to continue all these discussions. So thank you all very much.
Thank you. Thank you, Bruce, for hosting.
Welcome.
Thank you.
Thank you, Bruce.
You're welcome.